All right. Hello, Lyric Armstrong, your real estate agent and advocate. We are here in the Lenawee court. We're in the probate matter. This is the matter that's very sensitive. So if you have any apprehensions or emotional reactions to DV or things that can be highly sensitive in nature, this would not be the video for you, but we have a plethora of other ones to help you through the probate process. The overall theme of everything is just to make sure that you have a trust. You can put your business in a trust as well as all of your assets so that you can avoid probate having to spend years figuring out where your assets go and consequently costing your heirs and beneficiaries a lot of heartache and money. That's the thing. Right now, we are still in Dee Warner's matter. This is seemingly the end of the court for the day. This, I think, is one more witness, and then we're out of here for the day, I believe, is what we got going on. So come on, let's go to court, Judge. We are ready. We are ready for court. Oh, things are happening here. What's happening? Doing things. Okay, we're ready for court. Oh, don't forget to take care of that housekeeping. Like, share, and subscribe to the video. I'm going to go ahead and make sure I'm liking this video. If we're watching a video, they have put the time to put the content up. The least we can do is like it and subscribe to the channel. It doesn't cost us anything. It helps the channel out. So as I do it for any video that I'm watching, any channel that I am using and utilizing to converse with you and commentate, I just request you do the same for me. All right, let's get in.
1151852CA. All right, we are back on the record. Mr. Lieb, I have not seen your potential witness log in, and we have given approximately 10 minutes.
Your Honor, I understand.
And please be very on guard in case you haven't seen the other videos. This particular attorney has worked all the nerves that I have. Forget the last one. He's on all of them. Okay. It's not his fault. It's not his fault. He's doing his best. He's doing his best. He's just driving me crazy.
The witness log in, and we have given approximately 10 minutes.
Your Honor, I understand he's not available, but I also understand that the other attorneys have stipulated the fact that the affidavits can be admissible.
Counselors?
Not the case for me, Your Honor. The problem is I see a conflict attorney-client.
Since this video is broken up, I'm trying to condense our videos so that you can have the pleasure of watching a video without having long, extensive content. I'm not going to not commentate because that's what I'm here for, but nonetheless, I'm trying my best to keep videos a little shorter. So for those of you who didn't witness this earlier, the affidavit for which he speaks of is the attorney's affidavit that it was a potential witness. Okay, this particular attorney is not an attorney on this case, but has some knowledge of representation of his clients, the Warners, in previous time. And so that is considered hearsay. You know, bringing in a statement outside of court such as that is considered hearsay. They went through an objection process of it. I think the attorney was going to try and, log into Zoom and be a witness that way. And I guess that's not happening now. So consequently, he's saying, well, I believe that the other attorney will stipulate for this to get for the affidavit to ride. And he's like, no, I didn't say that.
Conflict in that Dee Warner was also an attorney for an entity which involved Dee Warner. And I think we'd have to have a release from her or her attorney. So I can't address that and stipulate Ms. Warner because I think that is a breach of ethics for an attorney to breach confidentiality of his client, Your Honor. And Dee is a joint client on this. So that's an issue that I see. Is I'll have to leave that to Ms. Berger to address, Your Honor.
And my understanding is that, having read the affidavit, it deals specifically with DDW Transportation and Dale Warner, not Dee Warner. So I don't believe there's a conflict there.
Transportation involves Dee Warner.
It does not.
Oh, that's right. Because
the affidavit in paragraph 5 does say I'm somewhat familiar with DDW investments and talks about having tax issues and such.
Yeah. So, where am I? Here I am. So the transportation company does not involve Dee Warner because Dale Warner started that entity after Dee Warner was quote unquote missing and or deceased, depending on when they noted her to be dead. They have deemed her legally dead, unfortunately. And so, but then now we have the other attorney saying there's other clauses in here that starts talking about the original company, which is the investment company for which Dee Warner was the CEO and owner of.
And they represented various Warner entities, so of the 7 paragraphs, 5 of them deal with.
And they're just saying this particular attorney, unless he produces as such, does not have a release from her saying that he is allowed to speak on these matters because of attorney-client privilege communication. And so any communication that he has with Dee is attorney-client privilege. Now, he also has that same type of communication privilege with Dale, but Dale is waiving his right to be protected from that and saying, yes, let him testify, or yes, let him, put this statement on the record and enter it into evidence.
Joint entities.
I couldn't tell you, I haven't looked at it. All I want to know is whether or not you all have agreed to allow me to look at it or not.
No, we don't agree.
To be honest, Your Honor, if Mr. Duva was available to testify, then I would, because I want to end this proceeding. But if he's not available, then I'm not so inclined, I suppose.
All right,
Yes, he's available.
he is not. Mr. Lieb informs us he's not available today.
Correct. Correct. I mean, if the court would like to adjourn it so that he could be available.
No, I will go ahead and step also. Then,
To what? The adjournment?
no, are you saying?
No.
I guess that I'll stick with the co-counsel, counsel on this side. If they are also in my position, then I'll stay.
Oh, there she is. The judge is finally.
Okay,
Yes.
so there's been a motion for an adjournment to allow the testimony of Mr. Dietz.
I would object.
I would object, Your Honor. I'd like to make my closing argument and bring this to a close.
This is a date and time, Your Honor. This witness could have been subpoenaed, should have been subpoenaed. We've known about this date plenty in advance. Subpoena takes trump over trial. The told trial judge, I've been subpoenaed. You have to be here.
Mm-hmm. So the witness that he wants to get in is in trial. They're making the rightful, notation that had this witness been so vital to this information, he should have subpoenaed the witness so that particular witness could have went to his trial judge and say, Judge, we need to postpone trial because I have been subpoenaed in a different matter.
So, no,
But he
it's
didn't do
another
that.
delay tactic for us to come back in yet another day.
Ooh,
in my opinion.
delay tactic.
Any good news, Ms. Heist?
I object to the adjournment on the same grounds as my co-counsel.
Very well. Okay, Mr. Leap, I cannot send to you an adjournment. I have to say, I do agree that there were measures that could have been taken to secure the presence of your witnesses today prior to this moment. So those reasons I will not be granting your motion to adjourn or to allow your evidence in as it is used. Anything else before we reach towards closing arguments?
All right, closing arguments. Hey,
Mr. Bowles.
all right. Make sense out of it.
I'll start off with some of the legal principles that govern this proceeding. I think I started off with that back in April, but it's been some time. I'd just like the record to be clear that this is a criminal contempt proceeding. Mr. Warner was.
So future reference, he said back in April, spent some time. Right now is September 8th, 2023.
Informed that this is a criminal contempt proceeding as opposed to a civil proceeding. He has a Fifth Amendment right to remain silent, which he appears to have exercised, as he's chosen not to testify. And I would also direct the court to a case called Anderson v. Johnson. That's 2014 Mishap Lexus 1284. It's a Court of Appeals decision from July 2014, where the contemnor, which is the person being charged with contempt, chose not to testify. And the Court of Appeals upheld the trial court's decision in imposing contempt because the trial court stated multiple times that it found the credibility of the other witnesses to in fact be credible. But given the fact that the contemnor did not testify, the evidence presented was uncontroverted. So if the court were so to find, it would not be error or depriving Mr. Warner of his constitutional right against self-incrimination. It would instead be finding that the testimony of Ross Dempsey and Zach Bach, and actually in part of Mr. Naring, were credible and uncontroverted, and were called.
Oh my God, Mr. Narek was the guy that was like kind of snarky and snippy. And he was the witness for Dale. And he got into this thing about the new company, transportation company, was created to evade taxes for the old company. And then he turned around and said all of the things that the old company owned, all of the assets that it owned, the new company utilized those assets without paying for them. There was never a bill of sale for them. And then they were able to use all of those assets and just keep on going. And they went ahead and had a new company. The new company was started after Dee passed. And when she passed or disappeared at this time, it was missing in the very beginning, according to the way they saw it at that time. Dale went ahead and started the new transportation company. He just came up there and validated the whole issue for the contemption. The contempt hearing that we're having is that this court put in an order that the assets and everything would be in place, not moved around, not messed with, so that they could go through the probate procedure. Well, the opposite side of Dale, all of these people, they went forth and did a motion for contempt to find him in contempt of violating that order, because he started a new company to, move money around and to do things as he see fit. And, everyone's representing it's to avoid taxes, which the IRS don't play. The IRS don't play. I don't know what makes you think the IRS plays. If they're going to, if they will put a lien on your house and a lien in your, and garnish your wages, what makes you think they're not going to do a lien on your businesses? It might take them a minute to figure out that you have a new business, but they're just going to put a lien on it. You're not going to evade them by any means. So I don't trust that argument. I mean, unless you just think you will, but you really are not going to.
Determine that beyond a reasonable doubt that these 5 acts have been proven. And once again, those are diversion from the DDW bank account generally. So specifically, there was an order entered on January 14, 2022 and served on January 18, 2022 that directed cooperation with Mr. Dempsey. Also directed that DDW investments cannot be dissipated. Its assets, the court has heard testimony from Ross Dempsey that in fact Mark Weisberg and Dale Warner did not cooperate with him, that in fact they impeded his investigation. They did not turn over documents as the court order entered. You've also heard testimony, and there's been bank statements that were admitted into evidence that show DDW investments account dwindled and DDW transportation's account, which was set up, started receiving funds. And in fact, some of the wires into the DDW transportation account actually noted that they were for DDW investments. Mr. Naring has testified that he did the same thing at the same spot, other than switching sides of his desk, with the same customers, whether it was investments, transportation, or Laidlaw. This court heard the testimony of Mark Weisberg from a different proceeding, which I quoted in my motion. And it said, I said to him, you testified that you formed DDW Transportation to avoid the tax liability of DDW Investments. Is that correct? Correct. DDW Transportation did business with substantially the same customers as DDW Investments. Isn't that correct? Yes. What did DDW Transportation pay, if anything, to DDW Investments? Zero. So Mr. Weisberg and Mr. Naring corroborated each other for the fact that transportation was set up to avoid the tax obligations of investments. It dealt with the same customers and deposited funds into those accounts. Even if those actions were done, some of them were prior to this court's January 14, 2022 order, they were mandated, they were obligated to disclose that information to Ross Dempsey. They did not. Mr. Dempsey testified that in fact, he had some general idea that a new company had been formed, but they stonewalled and stiff-armed and did not give him information with respect to that transaction. They did not give him information with respect to the fact that investments had essentially been allowed to wither on the vine, and this new company, Transportation, had been formed, was doing business with its with investments customers. And they continued to do that after the January 14, 2022 order. It did not disclose it. So I believe the first violation of this court's order has been proven beyond a reasonable doubt. The second violation was the sale of the assets. Once again, Mr. Naring testified and Mr. Weisberg both testified they did the same business with the same people at the same location with the same customers, only put a new name on it, calling it DDW Transportation, and then promptly sold it. The purchase agreement has been attached as an exhibit. No one has disputed or objected to the fact that that is the actual purchase agreement that sold the assets of what has been called Transportation to Laidlaw. One of the exhibits to the purchase agreement breaks out the purchase price, and one of those subparts is a customer list that we heard a lot about today. There were in fact customers that did business with investments and transportation and then became customers of Laidlaw. Mr. Naring testified that he was a critical component of that he had those relationships. We'll take him at his word that in fact he was instrumental in retaining those customers, but he started off as an employee of investments, transformed to transportation, and then
Now
became
Laidlaw.
an employee of Laidlaw.
And all the business connections and all the clients that he had went from each one of those entities. They went with him. They went with him. And it just begs the question, did you say this is a new company? Or did you say, oh, DD Investments is no longer, we're now the DD Transportation. Oh, DD Transportation has now been bought by Laidlaw. So how are you representing to the individuals of these new companies? And he never sent a letter. All his communications to the clients were verbal. He didn't do an email or a letter because they asked him for it. He says, oh, no, I just talked to them in about it. Very interesting, because require a written communication that says, I'm now doing contracts with this company because the old company has dissolved or whatever, but that's just me.
That transaction,
Me being a pain in the butt.
an employee of Laidlaw. That transaction was not disclosed to Mr. Dempsey. Mr. Dempsey testified to that. So once again, this court's order, and I won't belabor the point because I feel like I reference it every hearing, but it's quite clear as far as disclosure of assets, disclosure of transactions, and generally directing the parties to comply with Mr. Dempsey so he can do his job. They did not, in fact, do that. There's a specific injunction actually from attempting to sell, dispose of, transfer, encumber, or otherwise diminish the assets of DDW Investments.
And that's one of the number one problems, diminish. And how do you diminish those particular assets? By transferring your accounts payable from this entity to another entity, because now this this particular entity, the investment entity, is no longer getting payments, so no longer having those clientele invoices being fulfilled. And one of the other problems that Dale Warner has, is that his last witness testified that the business was able to run, the investment business was able to run and continue to move on, even though Dee wasn't around. So in one regard, you may say, how could that be possible if you need her signature on the checks, or you need her signatures on the agreements, or whatever have you? But according to their own witness, that was not a problem. They were still able to function and keep the business running. They started a whole new company to avoid taxes. However, in doing that, you have violated the court order, because you're diminishing the value of the company because you have taken away its income, for which you're not allowed to do.
That's from this January 22 order
Mhm.
of the court. And they were also directed to immediately turn over to the conservator all books and records of Warag Farms, Buyback, Cedar Creek Express, as well as those of DDW Investments. Mr. Dempsey testified that that did not happen. So we believe the second violation has also been proven beyond a reasonable doubt. The third violation was the SBA loan to Warag. The court has not received direct testimony regarding that. There was a loan application that was attached and was signed by Dale Warner and Dee Warner after the date that she went missing. Russ Dempsey did testify that he did not approve the signing on that loan application. Dale Warner has not contested the fact that either he or Mark Weisberg or somebody other than Dee Warner signed that application, and it was not disclosed to Russ Dempsey. Once again, a violation and failure to provide information to the conservator. The fourth violation, the new Warag bank account. Mr. Dempsey testified that that was never disclosed to him. Dale Warner set up a DBA account in the name of Warag Farms. The order states that they need to disclose all information, any information necessary to determine if any impropriety has occurred. They did not do that. In fact, they just deposited checks into a new DBA account that Dale Warner had sole control over, as opposed to the Warag Farms account that had historically been used to deposit checks. That evidence is also uncontroverted. Fifthly, diversion of Warag payments. This is closely related to the fourth count. So the new bank account was set up, and in fact, payments were deposited to this. By setting up a new DBA account and not disclosing it, he was able to avoid the involvement of the conservator. And up until 3 weeks ago, he exercised full dominion and control of that account and did what he wanted, how he wanted, and when he wanted. And that's also related to the September 2022 order of this court. That one hasn't necessarily been front and center throughout this process, but it was attached to my motion. That states that that Mr. Warner is obligated to provide a budget relating to all operations. That was subject of a civil contempt motion. We have, since that time, we have received budgets, but there is an element of criminal contempt with that same issue, given the fact that there was a directive to prepare budgets and provide them, and they in fact were not. So any one of those 5 violations is a violation of this court's order. Any one of those 5 violations is enough for a finding of criminal contempt. We did hear testimony from Todd Naring as well that corroborates these allegations. There was a last-minute attempt to call James Duzma and introduce an affidavit from Mr. Duzma. And even if that were allowed in, I would point out that there's no defense to a criminal contempt violation that the contemnor violated a court order on the advice of counsel. And that's Brown v. Brown, 335 Mich. 5/11/1953.
Okay, so we're now getting into the purpose as to why they were working so hard to get that attorney to come in. Is Dale wanted to say it's not nefarious that we created this new company. It's based upon advice of counsel that we created this new company. But you did it nefariously, most assuredly, because you didn't sell off the assets of the old company to the new company, even at a discounted rate. You didn't sell it off at all. You just took it over, so you stole them, right? And you have the problem now that you have violated the court's order. So here's another thing. When you go in to speak with an attorney and get legal advice, make sure you tell them everything. Don't hide things, because when you hide things, you're going to get advice based on what you tell them. And if Dale failed to tell them, we're in probate and probate has issued an order relative to the companies, and here's the order. Because if that attorney, which is one of the reasons why, the affidavit doesn't work, he needs to be there to cross-examine. But if that attorney read the order, he would definitely see that, there's a hold on the account. You can't disseminate and you can't diminish the valuation of the assets. And that's inclusive of the businesses. There's a lot of money to be made in trucking and transportation, and a lot of money to be made. Okay, a lot. So this is what Biggie meant when he said more money, more problems. Because this is like more money. A big company has the ability to make a lot of money, but in that instance, you have a lot of responsibilities. And then one of the number one responsibilities are your taxes, right? And trying to evade these taxes have done nothing. If that's the case, have done nothing but cause Dale a great deal of grief, because he's now going to be held in contempt criminally for the actions that he has done against this court.
In Chapel v. Hull, 60-167 from 1886. So fairly long-standing precedent that you can't say, oh, sorry, I was listening to my attorney, and so that therefore I thought I could violate the court order. So that defense really hasn't been proffered. There was an attempt to, but it really is of no avail given the case law in Michigan. So we are asking, and finally, when reviewing the legal sufficiency of the evidence, all record evidence must be viewed in the light most favorable to the prosecutor, or in this case, the conservator, to determine whether any trier of fact could find the essential elements of the crime were proven beyond a reasonable doubt. That's People v. Robinson, 475 Mich. 1. So we are asking today that Mr. Dale Warner be incarcerated for a period of 93 days. We're also asking that you pay a $7,500 fine to this court. As I indicated with the civil contempt hearing, there will be subsequent motions filed to determine the amount of time, effort, and energy that the conservator and his counsel have expended with respect to the two contempt proceedings, and there will be a separate fee request that Mr. Warner be paid, that Mr. Warner be obligated to pay all of those fees and costs. As a practical matter, we are aware that the harvest season is coming up. This is the beginning of September. If you were incarcerated for 93 days, that would take us to the end of November. We have been in contact with someone that can conduct harvest of the crop. Obviously, there will be a charge, but I just want the court to have the confidence that if indeed he is incarcerated, we are prepared to ensure that the fall crop is harvested and sold.
Right. He said, trust me, Your Honor, I will protect my client's interests in their financial necessities relative to harvesting the crop. We're not going to let the crop go to waste. And if you didn't remember or didn't know, Dale, I think, had a couple weeks or a week in jail. Him and Wiseman had a couple weeks or sometime in jail for the civil contempt hearing because they violated a court order of turning over records. And that was a civil violation. So they were found in contempt for that. This one is a criminal violation. So the stipend is a little harsh, even though the $7,500 to me is very lightweight, but whatever. He does say that there's other fees because of all the other hours that have been expended.
The proceeds are handled accordingly. Obviously, it doesn't do the estate good to have Mr. Warner incarcerated and then have a multi-million-dollar crop lost. So we are aware of that, prepared to protect.
Oh,
that asset
multi-million
if the
dollars.
court rules in our favor. I don't
I'm
have
telling
anything
you,
further, Your Honor.
it's business. This is money makers right here.
Reserve money
They making money.
Until after the others have.
Are
unless
they-
don't have a closing.
Yeah. Do they have a closing or are they just gonna join in here?
Thank you, Your Honor. I am in support of Mr. Polderman's asks of this court. In addition, I would just like to point out that there has been no real defense proffered by, maybe not defense is the correct word, but any other argument
Explanation?
proffered by Mr. Warner in relation to these accusations. There were some explanations provided by Mr. Nyrick, who previously, or who just testified today rather. But I find no real defense to these 5 allegations, and I do believe that the burden has been met. So at this time, I am in support of Mr. Polderman.
Brown?
Your Honor, as the guardian ad litem for Dee Warner, I have to express to the court what I believe is in her best interest. First of all, I think that she would want this court's orders to have meaning, to protect her rights. As this court stated before, it's been also my position that she has an equal interest. Right now, she's still alive. Of course, not determined that she's dead. Every enterprise that's involved with Dale Warner, she also has an interest because they are a married couple.
Oh, I
I
thought they
see
had
her
the, wait. I thought they had the hearing. Okay, so put it in the comment section. I could have sworn they had the hearing that they deemed her dead for purposes of this probate matter. So that's why I've been saying this whole time, because I've been saying legally dead because they had a court hearing about whether she was alive or not. Now he's making the statement that she's deemed still alive. Okay, interesting, because I thought he was the other lady is the guardian ad litem for the 11-year-old child that they have in common. So he's the guardian ad litem for Dee, and she's still alive. Okay, what did I miss? I must have missed a hearing because I could have sworn they ruled on that she was legally deceased.
Every enterprise that's involved with Dale Warner, she also has an interest because they are a married couple. I see her interest being dwindled away and exploited by Dale Warner. I believe that in fact, I'm going to say that 5, at least 1, these contempt of court charges, allegations, the petition, up to 5 have been verified. There's been no defense that would rise to the adequacy to not find Mr. Warner guilty.
Guilty is
You
criminal.
know that there are other arrangements made for the harvest. And at this point in time, I would support court finding Mr. Warner guilty and a 91-day sentence. Thank you.
Come on up, Ms. Heiss.
Thank you, Your Honor. Your Honor, on behalf of Mrs. Wilhelm, who has visited with the child face to face, I would ask you to consider that the position of the guardian ad litem for the child, the minor child in this case. We do support Mr. Polderman's motion and request for relief. It is in the best interest of the minor child to conserve the assets of the family. Mr. Warner has violated the court order put in place to protect those assets. In the responsive pleading, the argument has been made that the moves, the changes the sales have benefited the estate. And I think that's an ingenuous argument, as the conservator could have, would have, should have agreed. I think that whether jail should be levied or not in the short term will really hurt this child. Her experience of the last time this happened to her, she was sad, but she was not devastated. There are provisions in place for her care. So in the short term, it does hurt her, it does make her sad. In the long term, it benefits the child, though, to vindicate the order. of the law to protect the estate and to help this be more of a cooperative venture for the child. I don't think there's any evidence that the conservator would not have cooperated with the family, with Mr. Warner, and maybe if these moves were well advised, they could have used the conservator that was set up to protect the child. So I ask you to consider, though the ship has sailed on the child's best interests in life, her developmental milestones and the things that would have been best for her. Considering the current situation, I join the Mr. Polderman's motion and request for relief. Thank you.
I understand much of what she was saying relative to the end part of that, but I'm gonna let it ride. Because to me, it sounds like she's saying the demise of the mother has, put the child in a problematic state with her developmental concerns because she doesn't have her mother. But she's talking about Dale when he went to jail for the week or two, whatever time frame it was, when he was held in civil contempt, and how that had a negative effect on the child during that time frame. So I think I might just be misunderstanding some of what she's saying, because it could also mean that she might also be saying that the last time when he went to jail, there was lack of provision and care for the child, whereas this time, if he goes to jail, we have put provisions in place so that there is proper care for her, that though she may be sad, she will have the resources necessary. So that might be her argument overall. Some of those details, they missed me, but that's because I don't have complete familiarity with the case. This case has multi-layers, a million layers, so much going on here. When you have money, buddy, when you have money, you have cases in probate like this. You better get a trust. Well, let me find this thing because he's gonna be slow. Let's speed him up.
In order to support a conviction for criminal contempt, there's two elements that must be proven beyond a reasonable doubt.
Okay.
These two elements are that they are individually engaged in willful disregard or disobedience of a court order, and that the contempt must be clearly and unequivocally shown. Your Honor, I don't believe the conservative attorney has met his burden, and here's the reason why. DDW Investments LLC was owned by Dale and Dee Warner, regardless of whether or not there was one operating agreement or two. They are married and they join in the accountability of that company. DDW Transportation LLC was an entity that was created by Attorney Jim Duzman back in 2021. It was created for the purposes of assisting and maintaining the corporations as a whole, the Warner family companies. There was at the time, and you heard testimony, that there was an IRS investigation going on, that there had been payroll taxes that were due and owing, and the company was struggling. Even Mr. Bach, under examination today, admitted that these companies were very confusing, that each of the companies operated, had one role in one capacity and another role in another capacity. For instance, DDW Investments is a trucking company, but the equipment was owned by another entity called Cedar Creek Express. Warwick Farms LLC at one time had an agreement with Mr. Warner. I asked Mr. Bach about it. He didn't know anything about it, yet he was the accounting guru in the office to farm. And at a point in January of 2022, that agreement was terminated by Mr. Warner for the purposes of him operating under his Dale Warner Warwick Farms, Dale Warner DBA Warwick Farms, which was a DBA that had been in existence since even prior to Dale and Dee's marriage in the early 2000s. Dee Warner was well aware of the DBA. She was well aware of the intricate details of these companies and how they operated. She was in the office regularly, her testimony in that, and she was responsible for paying all the bills along with Zach, her trusted son.
Wait a minute, are we confusing facts here? He's saying Dee Warner was well aware of the DBA, and the DBA was created when? Because I thought they just stated that the DBA was created after her missing. Okay, I may have not paid attention close enough, because it does kind of irritate me a little bit. So maybe it's my biases kicking in, but I could have sworn I heard the previous attorney say the petitioning attorneys say, the moving party. I could have sworn I heard him say that, the DBA that Dale created and started moving money into was his own company. And it was, well, okay, he said that he moved the money after Dee was missing. So maybe the company was already started. Okay. But that doesn't mean she gave him permission to put her money into that company just because she knew that that company was started. Obviously, that company wasn't sufficient for doing that because they started a whole new company,
It disappeared in April of 2021
whatever.
and couldn't be found. Dale Warner contacted Mark Weisberg to come in to help him, to assist him in trying to figure out what was going on. Mark Weisberg worked for Dee and Dale Warner and was familiar with the operations of the various companies and was a person that Dale believed could help him uncover what was going on with the businesses. Everyone has testified that Dale Warner was a farmer, that his priority was the farm, that he was involved mostly with Warag Services LLC, a spraying company, that he was involved with Warag Farms LLC, and later Dale Warner, DBA Warag Farms, because he was involved in managing the farming operation. Cedar Creek is a corporation which owned the trucks and trailers of DDW Investments. Buyback, as you heard, was created out of the need for an entity to handle the land that was taken in a land contract with probate and settlement of the lawsuit with John Deere some years ago. So all of these companies work and roll together. And the fact of the matter is that even Zach Bach today testified that DDW Investments paid off most of the bills for the various companies, that he was a check signer, that he was involved in paying bills and invoicing the customers of DDW Investments, that he had the authority to sign his mother's name, issue checks. He even issued checks to her. I've never heard of this in my years of practice. Issued checks to her after she went missing because it somehow would have violated the IRS code for a S corporation. Seems pretty preposterous to me. But the fact of the matter is if you look at Mr. Bolderman's allegation.
I'm sorry. What's preposterous? That's not preposterous. She went missing, but she's an owner and she gets a salary. And missing could have very well be she went on vacation. She stepped away from the business for a while. Depends on how long he's making those payments to her.
They're serious allegations. But if you look at the court's orders specifically.
We missed that
When-
hearing because they didn't
Dale
record
Warner
it. They didn't stream
went
it.
to Jim Duzman, his attorney, and everybody agreed that Mr. Duzman was the attorney for the corporations about what to do with the growing payroll tax debt for DDW Investments. The suggestion was made to create DDW Transportation. There was also conversations, lengthy conversations with Lawrence Levy and Levy and Associates to talk about what was going to happen with the payroll tax issues in the IRS. And Levy and Associates was retained to handle that portion. When they were retained, there was approximately a $400,000 to $500,000 tax debt. I'm not making this up. I mean, there's actually documents from the IRS that suggest that. So when Mr. Bach said,
Do you know you gotta make some good money? You gotta make some good money to owe $400,000 to $500,000 in tax debt. And guess what? They've been saying it's not like taxes, period. It's payroll taxes. And payroll taxes are a percentage of what is being paid. That's some good money going through those businesses.
no, nothing. Oh, that's not true.
Wait,
That-
what?
that-
I'm sorry.
I'm not making this up. I mean, there's actually documents from the IRS that suggest that. So when Mr. Bach said that there was no, nothing owed, that's not true. That debt had accumulated over a year, and the documents provided by the IRS show certain pay periods for it.
But how would the court know if you guys didn't have the records? Like if you weren't allowing the other side to see these records, which was the civil Contemption hearing was about the fact of not having full access to the records in real time. Where's my guy? Where's the guy? Is that him? I think that's him. Maybe he's the petitioner. Whatever. There was one guy that was always on Zoom. It's like, we don't have the records and I want the records and I need direct access. Just give me the passwords.
When those payroll taxes were due.
Oh my goodness.
Mr.
Okay.
Warner used Mr. Weisberg and Jim Duzma and Lawrence Levy for the purposes of trying to keep these businesses alive. He, under the advice of Jim Duzma, his attorney, and Lawrence Levy, they suggested that the best way.
Wait a minute. He used the fired employee who was fired for money laundering, who had a felony conviction for financial fraud. He used him to help him keep the businesses alive, but it's not nefarious. It's not nefarious, Your Honor. We're not doing anything illegal.
Under the advice of Jim Duzma, his attorney, and Lawrence Levy, they suggested that the best way to not be saddled with the debt of DDW Investments was to create a new corporation.
Object, Your Honor.
That
There
is,
was no.
this is argument, Mr. McFarland.
This is not, is facts not in evidence. You can't just, not argument, this is closing. Okay, closing argument. But you can't just say stuff that's not factually into evidence. And that particular affidavit did not get into evidence. I wanted to say Judge Catherine is so cool. She's so cool. She's just sitting there. Yeah, what's going on,
It's
people?
taking facts that have not been placed into evidence. He's basically testifying. We objected to any documents by the attorney. They were not.
That's right.
There was no
That's
testimony
right.
to that. That was
That's
also-
right.
So. this-
Hello.
Response.
Yes, it's argument, and I'm allowed to argue my position. There was consultations with Mr. Duzma, talking about what.
You
Mr. Duzma said,
cannot
because it's not
testify
listed,
in
but
your
there were
closing.
conversations
Not.
related to creating documents. There have been documents.
Were you there, counselor? Stop. You cannot testify in your closing. Stop it.
Well,
Judge.
Mr. Lee, just so you're aware, I am not going to consider facts that were not brought into evidence, so it doesn't do you any good to spend time talking about that.
I understand, Judge, but the articles of incorporation of DDW Transportation were created by Jim Duzma. They're an admitted example.
But the reasoning behind them and getting advice from
Mr. Duzma
your
created DDW Transportation.
counselor to do so was not admitted.
That entity listed Dale Warner as the
Lord have
incorporator
mercy.
because Dee Warner was unavailable. I mean, unless somebody can show where Dee Warner is, she was not available. And on the advice of Mr. Duzma and Mr. Levy,
She's dead, but she's unavailable to sign these documents. I'm gonna go ahead and do that thing against the court order. Let's be mindful. This is against. Now, let's take it like this. If you break your mother's rule or your father's rule, and do you go home and say, you know what, I broke your rule because my friend said it was a good idea. My teacher said it was a good idea. You know, I was advised by someone else outside the household, and that's the reason why I broke the rule. You think that your mother or your father are going to be like, oh, okay, because your teacher said do it, it's A-okay. Oh, okay, because your friend said do it, it's A-okay. No. So that's where they are right now. They're saying, Judge Catherine, you gave us a ruling, you gave us an order, you told us not to do something. Someone outside of your courthouse told us to go ahead and do it. So we followed their instruction. Do you think she's gonna be like, oh, okay, well then don't worry your little pretty little head about my little bitty order. It don't matter. It's okay. Don't worry about that. Really? That's not a good defense. It's not a good defense because you know better. Counselor that's at the podium knows better. And quite honestly, it's good that the other attorney didn't come for testimony, because if he came up there and got on the stand and said, I advised my client to disobey and to not comply with this court's order, he would have a problem on his hands. It would be an ethical problem, and he could get his license stripped from it. So I'm glad he didn't testify. Now that I hear this, I think about it a little bit more, because you can't do that. You cannot advise your client to break the law, and you can't advise your client to break the order. He has an order that told him not to do anything to that business that would give it less valuation?
The trucking company, which was the more profitable portion of the Warner family of
The
companies,
portion. They did
was
everything
to
though.
continue operating.
They did the same
That
stuff.
was in August of 2021, long before this conservatorship was created. Dale
Hmm.
Warner believed that if it didn't affect Dee directly, if it didn't involve Dee directly, that he did not feel the
Your Honor,
necessity.
once again, I'm objecting. There was no testimony by Dale Warner that was not placed in evidence.
Keep on it. Yes, Dale. We don't know what Dale believed because Dale didn't testify. You cannot testify for him. Move on.
Objections are sustained.
Yes, thank
Your Honor,
dude.
when Mr. Duzma created the corporation, he listed Mr. Warner as the only incorporator because D.M. Warner was not available. That trucking company,
Okay, Dean's not
Mr.
available.
Narek testified that it operated and that there was essentially the same businesses as DDW Investments.
Mhm.
The fact of the matter is the bank account was opened before this court's order. The transformation of the entity, DDW Transportation, was created and put into place before this court's order. And the fact of the matter is that at some point in time, Mr. Dempsey was appointed by the court. Mr.
So I really hope that this attorney does not believe that because the court order was the September, October, November, December, January, 5 to 6 months later, no, about 5 months later, that he doesn't believe that because the court order was later, that in fact the court order, the things that were done prior to do not count. Because what you should do at the time of the court order is say, Your Honor, we have a problem. I don't have the ability to comply with certain aspects of this order because there are entities that have already been created, things that have already been done prior to this order. Please take that to an account. Please make this order, inclusive of the new entities, or just ensure that, you understand, Your Honor, you put on notice that, these things have already occurred in the attempt to do what's best for the order for the company. But see, what he wanted to do was avoid the court having jurisdiction over the new entity. So, because if you didn't care, and if you're saying you're just trying to avoid certain debt of the old entity and trying to preserve the income of the old entity, then you should have offered that new entity up as being governed by this particular proceeding as being an asset of Dee Warner, at least a portion thereof, because you're not trying to write her out of it, according to everything your attorney is saying.
Dempsey testified that he came out, I met with him, Mr. Westbrook met with him, Mr. Warner met with him, and others met with him to go through all of the accounts of DDW Investments, DDW Transportation, the various other corporations, Warwick Farms Services.
Okay, so we feel like we're slow again.
All of those
Yeah.
companies. Mr. Dempsey testified that he was given an access code to get into all of the QuickBooks accounts. He testified that he was provided bank statements for all of the accounts. He in fact testified that he came out fairly routinely to visit with Mark Weisberg and Dale Warner. And so he was very aware of what was going on with not only the trucking company, but the farming operation. So when Mr. Polderman suggests in his argument that Mr. Dempsey didn't know or wasn't aware, that's not true. Mr. Dempsey testified that he was given access to that stuff. Mr. Dempsey was provided all of the documents leading up to this court's January 2022 order. And if the court looks at that January 2022 order, it doesn't affect DDW Transportation at all. In fact, the order that was prepared by Mr. Manna, who was Mr. Dempsey's attorney,
That's no
specifically deals
problem.
with
That's the whole problem.
a number of the Warwick companies, but not specifically. In other words, Warwick Farms and Warwick Farm Services and Warwick Farms LLC are all seem to be Warwick Farms. But DDW Transportation is nowhere to be found in this order. Again, Mr. Warner didn't feel an obligation since it didn't involve his wife, didn't let anybody know, felt it was just him. Didn't
Oh,
do it to pay anybody.
please. Oh,
He's been
please.
approached by law enforcement, he's been approached by the conservator, he was approached by others, and he has never denied access. Now, Mr. Dempsey then mentioned at some point in time that he wanted to come out to the house to inventory some things, and that I was hostile to him. But we've got a video of that entire encounter, and I'm not 15 feet from him.
No, I want to objecting that video.
So-
It's not been placed in evidence.
So, Mr.
Thank you.
Accurate.
That's it. But he did testify that I was offensive to him, and I was not.
The objection as it relates to the video that was not produced into evidence is sustained.
Correct. Mr. Dempsey then testified that during February, March, and April of that year, he was very unavailable. He had a sister who was suffering from a terrible condition. He had clients that his brother in their CPA firm were having to deal with in tax returns that had to be prepared. He had never been a conservator before and really wasn't sure what else had to be done on a timely basis, and he resigned. Mr. Dempsey, frankly, was not as available as he should have been during and within the time that he was the conservator. Now, that doesn't mean that Mr. Warner didn't have an obligation to follow the court order. The fact of the matter is, he did follow the court order. And if you look at the court's order from January of 2022, he did turn over all the documents that were requested in this order. The books and records of DDW Investments LLC, in which Dee Warner owns 100% of membership. Well, we know that she doesn't. That's a question of fact. But those records were turned over. The books and records of Warwick Farms LLC, Warwick Farms Services LLC, Buyback LLC, and Cedar Creek Express LLC, in which Dee Warner owns 50%. Those were all turned over. And we have transmittals to show that those documents were turned over. The personal assets, including the jewelry, bank accounts, safety deposits, investment accounts, and other personal assets, those were all turned over. DDW Transportation involved only Dale Warner. And because it involved only Dale Warner, he opened the bank accounts in order to be able to handle the depositing of checks for the entity. It doesn't mean Dee Warner wasn't involved. Again, they're a married couple. And as a married couple, their assets are still joint unless this court determines that they're either not married or she's deceased, which in that case would be a decedent's estate. Everything that Mr. Warner did was to benefit the family and family businesses. There has been no evidence whatsoever that he did anything affirmatively to deceive anybody, to somehow harm the family businesses. You know, there's been this allegation that they got an SBA loan. That SBA loan was used for the sole purposes of paying down debt at banks, which benefited Dee Warner. The sale of DDW Transportation. At the end of the day, there was no actual assets that were sold. It was customer relationships that Mr. Neverett testified to. There was no proprietary customer list. There were relationships. There were assets that were from Cedar Creek Express, of which both of them had a relationship, and both had the opportunity to sell those assets. So he wasn't violating any court order by doing that. Next, Mr. Warner received that SBA loan to pay down the banks and to pay down debt. And all of the money that had been used from the sale was held in Mr. Duzman's client trust accounts. One of the things in Mr. Duzman's affidavit is that, but for a court order, everything was held.
The affidavit hasn't been introduced into evidence.
The conservator received all of the monies that came from the sale of DDW Transportation, the late line, that benefited Dee Warner. It helped to pay down the debt, and it's the $800,000 that's sitting in the conservator's account right now that's being used from the Cedar Creek sale, the sale of the Cedar Creek trucks that have been used in this case. So all of that benefited Dee Warner. Since 2021, the tax liability at DDW Investments has gone down substantially from $350,000 in payroll tax liability down to less than $100,000, and that essentially will be appealed to the IRS. Then we come to the September 22nd, 2022 order, and in that order, there's this allegation that somehow Mr. Warner used his position with Dale Warner, DBA Warwick Farms, to somehow mislead the conservator, to somehow not tell him about this DBA, which had been in existence for 15, 18 years. That September 22nd order said nothing about Warwick Farms services in the relationship to Dale Warner, DBA Warwick Farms LLC. So if you go through these violations, Judge, the first violation, there's a dispute as to whether or not there was 100% of DDW Investments and whether or not there was an issue as it related to the diversion of money. There was no diversion of money. DDW Investments is still there, still operating. It's got a tax debt of $100,000 that has been whittled down to $500,000. It will be appealed to the IRS. The second violation, sale of assets. Mr. Warner believed he had the ability to sell DDW Transportation LLC because his wife wasn't on it, but that she would benefit from the sale of the business and the relationships, but also the sale of the trailers and trucks that are being held by Cedar Creek Express. So there's no violation there. The third violation was a loan for the SBA to help with Warrag Farms LLC. It
Can
is
you see that?
was
Look, watch this.
that are being held by Cedar Creek Express.
Watch
So
the judge.
there's no violation there. The third violation was a loan for the SBA to help with Warrag Farms LLC.
I wonder if the judge is like jerking back, like, really? You really believe there's no violation there, do you?
It is uncontested that that loan was done to pay down debt.
Or just
It basically
reading?
refinance the debt of the companies. How could Ms. Warner not agree with that? The fourth violation was the setting up of a new Warrag bank account. Well, there was no setting up of a new Warrag bank account. The account was set up as Dale Warner DBA Warrag Farms, and that account was set up because Mr. Warner had a contract originally with Warrag Farms LLC. That contract expired in January of 2022. He then began farming as his DBA. He needed to make an
Oh my
arrangement
goodness.
with FSA, which is an insurance company. That insurance policy, he believed, needed to be in a sole.
Object, Your Honor, there's no testimony from Mr. Warner, so we cannot say what he believed or didn't believe. That's facts not in evidence. Once again.
Well, it deals specifically with the reason for the bank account.
But the objection is sustained. We did not have any testimony as to the thoughts or intentions behind any action taken by Mr. Warner.
So the bank account was set up for the purposes of being able to maintain the other operations, since Dale Warner was the only person that was doing the farming.
Or once again, there was no testimony to that.
Sustained.
Your Honor, Mr. Polderman mentioned purchase agreement for the Laidlaw purchase, and the fact of the matter is that it lists a customer list, but that document was drafted by Laidlaw. There was no customer list. There were no assets that were.
Your Honor, no testimony, once again, about who drafted the list.
The document speaks for itself. It was attached as an exhibit.
Correct.
Hold on. So Laidlaw purchased the company, which is a transportation company, and now he's saying that the customer list, though the acquisition documents include that there's a customer list and that's a part of their acquisition and purchase, that was somehow not done, even though there is a list. Okay. But yet they have the same clients because his witness testified that Laidlaw has all of those clients.
Anyway, I'm going to wrap up, Judge, but in the end, Mr. Warner has not in any way attempted to deceive or violate this court's order. He did everything he could to maintain the farming operation and to make sure that the entities were secure. The monies that came, again, from the Laidlaw sale were held in Jim Duzman's client trust account and were never dissipated. I mean, if he really wanted to be deceitful, he would have spent that money, and he did not. That money is left for the conservator to manage, and that's why that's one of the issues with the monies that they have in their account today. We believe that Mr. Polderman has not proven beyond reasonable doubt, a very high standard, that Mr. Warner has done anything illegal or unethical. The court ordered Mr. Warner and Mr. Weisberg to produce documents back in 2-3 weeks ago. Many of those documents had already been produced. Those documents, some of them were transmittals that had been agreed to back in March.
Judge Marcellus is drilled into the closing.
So there's been no deceit here, Judge. And the fact of the matter is it's offensive, really, that I think they're bringing these charges when, in fact, Mr. Warner did everything he could do to help the Warner family companies. And that Dee Warner has not at all been harmed whatsoever by any of his actions. But the bottom line is he didn't do anything to avert the court, did not do anything to deceive the court, didn't do anything to evade the conservatorship. You know, we've heard this testimony from, excuse me, we've heard this statements from Mr. Polderman over and over again that there were no optics in the farming operation. Well, that's not true. That's not true. They've known about the farming operation. They've known about DDW investments for quite some time. They were well aware of what DDW transportation was doing, how it was doing it, and the fact that it was sold for profit, not illegal and not a violation of this court's orders. So I would ask that you find Mr. Warner not responsible or not guilty of criminal offense.
Is your motion? Did you have any final?
Your Honor, the Warrag Farms, Dale Warner DBA Warrag Farms account was set up in November of 2021. This court's order specifically directed that information be provided to Russ Dempsey to determine if any impropriety had occurred with respect to Warrag Farms. That information was not provided to Mr. Dempsey. Essentially, Mr. Lee's argument is, well, you never caught us and we never told you because we didn't tell you, you didn't put it in the order, so it was okay. Of course,
that was not what I said at all. And it's a complete mischaracterization of my argument.
just let me make my argument. I'll let you make yours.
The objection is overruled. It is argument at this time.
So that the DBA account was never provided to Mr. Dempsey. They existed at the time of this court's order, and they simply didn't tell him. And so Mr. Dempsey could not, in fact, determine if any impropriety had occurred with respect to Warwick Farms LLC, i.e. money wasn't going into his account because they didn't tell him. Same with DDW Transportation. The defense says, well, no harm, no foul. None of the court's orders addressed that. Well, of course they didn't, because people didn't know what was going on. We have Mr. Dempsey's affidavit saying, hey, wait a minute, I've been told that there's going to be a sale happening. I don't know the details. That's what led to entry of this court's order of Dale Warner, Mark Weisberg, anybody served with this order, tell the conservator what's going on. Mr. Dempsey never even got a copy of the purchase agreement. He was not involved in the transaction. He had no idea what was going on with.
That's not true. He was provided a copy of it.
He was not provided with a copy of the purchase agreement. No, he was not. So those provisions of this court's order were extremely clear. Couldn't be more clear. In fact, provide the information, cooperate, let the conservator do his job. What did they do? They in fact went and sold the only asset that was producing revenue, or the asset that was producing the most revenue, DDW Investments. And this fiction that's been put forth that, well, the customers really could go anywhere. We heard from Todd Naring saying, same customers, same spot, same contacts. There was no difference between investments and transportation other than what name they decided to call it at any given time. So I was protecting the Warner companies to shut down and sell the entity that's producing the cash. How was killing the goose that's laying the golden egg a benefit to the estate? Quite the opposite. And throughout this process, this court we've been here over a year, asking for information, filing motions, having hearings, racking up fees. This is not cooperation. This is not what cooperation with court orders looks like.
You hear that? Racking up fees. This is why you put it in a trust. Racking up fees. That's what they've been doing over a year. And where are they? Still asking for information.
Cooperation does not look like somebody blocking the entrance so I can't go in. It doesn't look like providing half the information. You know, a half truth presented as the whole truth is nothing but an untruth. They've had multiple opportunities to provide information, to provide it to Mr. Dempsey. They simply would not do it. And but for, I believe it was Greg Hardy at the time and others saying, there's a sale happening, you successor conservator, you need to find out about it, and sending letters and attaching those funds. Those weren't willingly turned over either. It's constantly been catch. There's been a clear showing that they had zero intention of following this court's order with a full disclosure to Mr. Dempsey and a full accounting and full access to funds.
Thank you. Well, we're at 4:25. The court will deliver its ruling on the motion in conjunction with some of the other hearings that we've got already on September 13th. Commencing at 9 a.m. We have a petition, closing arguments on the petition to declare death. We'll schedule this for 10:30 to occur directly before the hearing on the first accounting.
September 13th.
Remain in full force and effect pending resumption of our proceedings on Wednesday. Thank you, ladies and gentlemen.
I think we actually have some hearings on Monday as well on a fee application and to retain a professional.
All right. You think we have more time than Wednesday? Is that what you're saying?
I believe we do. I think we have a full day set aside on Monday,
I have a half day.
or half a day.
Preference, Mr. Lee?
I would prefer to Wednesday.
Monday, you're right.
We don't know that we may withdraw our objection to the fee issues. I need to discuss that with Mr. Warner, and if that's the case, then there would be no basis for us to be here on Monday.
So there's more time. And there's a second motion to engage professionals. So, I mean, it's 4:30 on a Friday. So if we could stipulate to both those motions, and I do agree, we wouldn't have to be here on Monday, but I don't know that I have that stipulation for Mr. Lee.
I'm not going to step into your negotiations process. Ms. Berger, do you have a preference, Monday or Wednesday?
I believe we have less matters scheduled on Monday. Right now, my calendar reflects that we have a review on the civil contempt, we have closings on the ML case and your ruling, and we have the second day of the accounting unit. I would prefer Monday just for ease of scheduling my brain.
Ms. Hines, do you have a preference?
Ms. Wilhelm will be back next week, starting on Monday.
She's actually asked to be excused from the hearings that have been scheduled for Monday. So if we put this one on Monday,
So why don't we put it on Wednesday? We have the other man.
please don't interrupt. Ms. Heiss, I would assume you would be tasked with covering for her again on Monday if we schedule it Monday.
And on that basis, I think that Wednesday would be better because I'm out of town that day too, so.
All right, looks like we will remain with the original Wednesday 13th at 10:30 in the morning for the ruling on this one. Anything else?
Nothing further on.
Right.
All right, so court is adjourned. Put it in the comments section. Do you think Dale is going to be found in contempt? Or not? Contempt or not? And take into my consideration, it's the same thing. If you, are a teenager, you break your mom or dad's rule, you get to come home and say, oh, well, my teacher said I could. My teacher said we could do that, or my friend said, or my friend's mom, or, whoever. No, they're not running my household. I said, you're not allowed. So I cannot see Dale not finding himself in criminal contempt. I think the reason or the potential that he might have some kind of leadway or, some kind of saving grace would be the fact that it's criminal and therefore it's beyond a reasonable doubt, not just the preponderance of evidence. So it's a higher standard of proof. So that would be his only, saving grace that I see. But even his, of course, we didn't get to see the morning hearing because their Zoom wasn't working out of the courthouse, but his afternoon witness kind of told it all, right? He told it all. He said, yeah, we were doing the exact same thing. I think I moved to the other side of my desk. I think he was trying to be snarky when he said it, but all he ended up doing was proving the petitioner's, set of facts, that there was no difference between one entity and the other. They truly did not take the initial entity's interest into concern and protect it to the fullest extent. Though Dale is representing that it somehow protected it from the IRS, and the IRS appraiser or, analyst looking at this right now is pulling out that code and seeing what they can do because they're not liking this. They're not liking this. This is a high profile case. Now you're saying that you started up a whole new company to evade taxes. And you're saying this in public and this is on Zoom and people are getting wind of this as a potential workaround. They're not liking it. They also are not liking the fact that I'm concerned about the attorney who, was willing to put an affidavit. It didn't get into the record, but had it been put into evidence, like, will he be barred? Like, will he get a disciplinary hearing on his license because of it? Advising your client to break the law, advising your client to evade taxes by starting a whole new company. That's what your client just said you did. So that's interesting. All right. So I'm Lyric Armstrong, your real estate agent and advocate. We have learned a lot. We have gone through a lot. This is a lot. And I'm still confused. Could have sworn we had a hearing with the detective saying that she is presumed dead and that they are investigating her murder. They have moved on from missing person to murder. So could have sworn we came to the conclusion that she was found dead legally, but I guess not, because in closing argument today, we have petitioner stating that she's still, or not petitioner, one of the adjoining petitioners stating that she's still alive according to the law. So interesting enough. And very fast and loose from Dale's side, oh, well, we're married, she's still alive, and so anything I own, she owns. We know that not to always be the case because, like I said, if you have an interspousal declaration, the spouse themselves has to say, no, I have no claim to this, and put it in writing and sign it, notarized. But if you have something like that on the books, then it's not community property. So I guess you're saying, well, since I opened up the company after her being deceased, she still has a claim to it. But guess what? So does her heirs, because if she's dead, her heirs have an interest too. And you didn't disclose to them. So that's the violation of the court order. You didn't disclose to them. And the company for which is listed in the court order is the only company for which the court was made aware of. And in that it said, do not disseminate its value, do not diminish its value, and don't dissolve the corporation. And you diminish the value. You took its assets, you gave it to a whole new corporation. You didn't do a bill of sale. You didn't pay for those assets. You just took them over in a whole new corporation. Okay. All right. So I don't know. I don't know if Dale has a dog in the fight, if he's going to be able to evade going to jail, since he likes evading taxes. Let's see if he can evade going to jail. His attorney, I don't know. He has not been someone that I can watch and agree with. I don't really necessarily agree with his line of thought. But I guess, he has to defend his client. So it may just be he's working with the facts he's dealt with, the hand he's dealt. So maybe that's the issue that makes me feel so disjointed whenever he goes into anything, because he continuously either brings up evidence that is, brings up facts that are not in the evidence, or he gets on to irrelevant matters, or his thought process in defense is not really cohesive. And it might just be that there is no true defense. And so he's trying to make something of nothing. Maybe that's the issue. So I'm sure he's divine and well-educated and extremely phenomenal at his job. This particular case is not doing him justice. So make sure you like, share, and subscribe. So as always, we are here to learn. I'm commentating from the space of being licensed and certified. So there are a lot of people that are commentating on different aspects just to give an opinion, but I'm doing so to help you see things in a different light so that you can learn from the mistakes or the actions or inactions of another person that brings into litigation, with the hope that you can do something better for you, your family, and friends. So share the information so others can learn. Things that are happening in probate are highly important for all of us. Whereas landlord-tenant may or may not affect you, but probate will definitely affect you, because if you're living, you will go home to heaven, hopefully, if you believe in such. And if so, we want to make sure that we have put our ducks in a row so that things that we own go to the people we wish for them to go to, without diminishing their value. You heard what he said. We've been here for over a year, racking up fees, and that is not in the best interest of the trust and the estate. It's actually the opposite to do so. So that's what happens when you own things, right? So get that trust together so that your heirs can, in fact, avoid probate. Lord, have mercy. Talk to you later. See you at the next video.